Welcome to day 4 of the first ever Philippine Harm Reduction Summit, Rethink, Reshape, Reimagine. We are down to our last few sessions and our discussion now is entitled Plea-Bargaining. Kumusta na ba? In this session, we take a deep dive into the plea bargaining process from the judicial system all the way to the community programs to examine the current outcomes and potential opportunities as regards plea bargaining in drug cases. Yes, years after the enactment of Republic Act number 9165 in August 15, 2017, the Supreme Court promulgated the Espinosa versus Lobrico decision declaring Section 23 of the law as unconstitutional and thereby allowing plea bargaining in drug cases. A more recent decision will affect this judicial policy, and we hope to update you today. Our session today, Plea Bargaining Kumusta na ba, will be a discussion with you and the following speakers. First, I am Mimi Campos Banayat, a legal and advocacy specialist for IPG. I am also involved in litigation, and I will be your moderator for this session. Our panel includes Attorney Sikini Bokla Bastilla. I know him because he's not only a wide reader and because I love books, but also because he knows movies like he really knows movies. Bok is a lawyer and a drug policy advocate. He earned his Juris Doctor from the University of the Philippines and practiced law in banking, real estate, corporation, contracts, and litigation. He is the executive director of the Caloocan Anti-Drug Abuse Council and the head of its implementing arm, CADAO. Has also set up the first community-based rehabilitation center in the region. Bok sees, hears, and feels firsthand the experiences of plea bargainers. And we also have attorney Mary Catherine Alvarez, my manang during harm reduction events. Kathy is a lawyer and advocate of drug policy reform. She is the executive director and founder of the legal service group Street Law PH. Prior to her work in drug policy reform, Manang Kathy worked in HLAF or the Humanitarian Legal Assistance Foundation as a jail decongestion officer. She has knowledge of the experiences of PDLs or persons deprived of liberty, specifically on their concerns before their arraignment and entry of plea. Okay, our main presenter is Judge Corazon Gaite-Llanderal. Our Judge Azon dedicated her life to public service. She was a public interest lawyer working with traditionally marginalized sectors, studied academia, and worked in the area of prosecution under the Department of Justice. She now sits as a presiding judge in the Regional Trial Court Branch 40, which is the Special Drugs Court of Misamis Oriental and Cagayan de Oro City since 2010. Good day, Judge Son. We are ready for your presentation.
Thank you, Mimi. Okay, good afternoon. Good afternoon, good evening, good morning to everyone, wherever you are around the world. Thank you very much to NoBox, to the organizers for inviting me to this great conversation, to this very informative, relevant, and timely event. When I first got the invitation to participate in this summit on harm reduction, I felt glad and excited to be able to share my experiences as a drugs court judge. I was especially excited about sharing the effects of plea bargaining, which is a fairly recent development in our line of work, and to view it as a process that promotes harm reduction. I was also eager to hear from the panelists about their experiences as participants and stakeholders in the activities generated by the plea bargaining process. 2 weeks ago, however, my feelings about attending this summit changed to one of urgency and concern in view of a recent development in our legal system. I am referring to a case recently decided by our Supreme Court, which has the imminent potential of reversing the tide and nullifying whatever gains we have made with the introduction of plea bargaining in drug cases. I have been informed that the case has not yet attained finality. There are moves to have the decision reconsidered. Nonetheless, it has certainly caused ripples of alarm, disbelief, concern among judges, prosecutors, lawyers, and most of all, the people who are charged with drug offenses under RA 9165. So the title of this session, which is Plea Bargaining, Kamusta na ba, has taken on a different nuance, as the foremost and urgent question in the mind of people nowadays is this: plea bargaining, pwede pa ba? Paano kung wala ng plea bargaining? Okay, to answer these questions, I have tailored the presentation to a sharing of my experiences and observations as a drugs court judge for the past 11 years. I will compare the way things were before plea bargaining was introduced in 2017 to the way things are now, and I will make a brief discussion on the current legal obstacle that we are facing. In closing, I would like to propose some ways forward. To better understand why we are where we are now, or why we are still where we are, I invite you to take a look and re-examine our law on drugs, RA 9165, specifically the Declaration of Policy, as this provides the context for what our government is doing. I must confess that having attended several discussions about harm reduction, referring to policies, programs, and practices that aim to minimize the negative health, social, and legal impacts associated with drug use, drug policies, and drug laws, I have developed some kind of a new lens by which I view our law and our practices. So let's look at our declaration of policy. For example, I see some red lights, red obstacles, and a green light for harm reduction in the declaration of policy. Look at paragraph 1, the phrase, dangerous drugs as one of society's more serious social ills. Note, it is dangerous drugs per se, which is labeled as an ill or as a problem. It's not use of dangerous drugs or misuse of dangerous drugs or abuse of dangerous drugs. So I see that as a form of demonizing drugs, which runs counter to harm reduction policies, which would rather educate people about drugs than scare people or instill fear about them. Let's go to the second that second policy. The phrase there, campaign against the trafficking and use of dangerous drugs. Obviously, this is the basis for the criminalization of the use of drugs, which we have learned is actually counterproductive and harmful. Of course, we have a green flag. We have a green light here for harm reduction in policy number 3, which talks about programs of treatment and rehabilitation. Let us go back. Let's just look at some of the penalties of the cases which are usually filed under RA 9165. Of course, I'm sure you're all familiar with that section 5, which is for selling, with a penalty of life imprisonment to death, a fine ranging from 500 to 10 million, regardless of the amount of drugs. For possession, penalty ranges from a low of 12 years at least, and 1 day to life imprisonment, depending upon the amount. So my observation is this. RA 9165 was enacted imposing harsher penalties, supposedly to deter further commission of drug offenses. We all know, however, that the number of cases being filed involving violations of RA 9165 have steadily increased through the years. And this seems to prove that the law has failed to deter people from further committing said violations. For Section 15, which is also controversial, if you remember under the Declaration of Policy, the declaration warns people about the harmful effects of drugs. So the Declaration of Policy itself tends to view the use of drugs from the lens of law enforcement and criminal law rather than the lens of public health. This is where it is important to understand that the lens by which we view the drug problem influence the way we address and find solutions to it. One particular act, when viewed from different lenses, would produce different results and reactions. For example, if one views relapse, through the lens of public health and harm reduction, one would see it as a natural occurrence, part of a normal process of recovery and rehabilitation. But if you view relapse from the lens of law enforcement and criminal law, relapse would be regarded as something negative and undesirable. We would use terms like habitual offender, recidivist, habitual delinquent, and the reaction would be impose stronger penalty. So you see how the lens by which we view a certain problem gives different reactions depending on what lens you're using. Let's move to other red flags for harm reduction in RA 9165. And these are the two controversial sections. One is Section 23, which says that no plea bargaining is allowed in drug cases. Of course, we know that this one has already been rendered unconstitutional by the law. My point is this. We know that plea bargaining is allowed in many other criminal offenses, especially even in offenses where there are private offended parties. But in RA 9165, it is not allowed. The second one is non-applicability of the probation law for drug traffickers and pushers. This one I find a bit odd. I do not know why they have to put there. Any person convicted for drug trafficking or pushing under this act cannot avail of the privilege of probation. This is a surplusage because under the probation law, you really cannot apply for probation if you are convicted for drug trafficking, because the penalty for drug trafficking makes you disqualified to avail of probation. So I don't know why they have to put that there. But my thinking is that this is another message of scaring people off from drugs. Okay, so let us look at, as I said, I will try to compare the way things before 2017. Okay, pre-2017, because we know that plea bargaining was allowed beginning in 2017. So before 2017, actual cases filed, 98%, more or less, these are just my estimates. So cases filed in court involved the following violations. Section 5, sale, possession. Section 12, possession of drug paraphernalia. And Section 15. Through the years, medyo bumaba na yung Section 15. Probably because, the Section 15 says, if you are also caught in possession of an amount of drugs, you just file Section 11, which is a higher penalty. And then 98% involved methamphetamine hydrochloride or shabu, probably 2% marijuana. And then amounts involved are very minimal and minuscule, less than 1 gram of shabu, for example. In all my years as the drugs court judge, 11 years, I've only had a very few petitions for voluntary or involuntary rehabilitation, probably 5 or less. Without plea bargaining, who are the actors in the process? Basically, RA 9165 follows the general criminal justice system involving the 5 pillars of the justice system, which are the community, the police, the prosecution who comes to court and presents the case, prove the case, the court, and the corrections. I'd like to emphasize, however, that in drug cases, corrections come not only at the end when a person is convicted, for example, because in most drug cases, once a case is filed, the accused is already in jail and detention because they are hardly able to file a bail. I'll explain that later. So without plea bargaining, all cases had to undergo trial. That was my reality from 2010 to 2017. Every day I am conducting trial, day in and day out, of drug cases involving minuscule amounts of drugs. With the high volume of cases, detention centers were jam-packed as majority of criminal cases involve drugs cases, and majority of accused in drug cases are detention prisoners, either because their case is non-bailable for Section 5 or the recommended bail is way beyond the capacity of the accused to pay. For Section 11, the lowest penalty is 12 years. So the usual amount is 200,000 pesos. So there, we are contributing. Drugs courts are contributing to the jail congestion in the Philippines. I was trying to look for figures on jail congestion. I saw this article on Philippine Star, which compared the jail population from 2016 to 2018, apparently to show that there was some easement there was a lowering of congestion when the plea bargaining was introduced in 2017. Because if you look at the figures, 2016 had congestion rate of 511, 2017 was 612, it went up, and then 2018 with plea bargaining, it went down to 439.48% congestion rate. But you see, this is a national average. If these figures would change definitely for jails in highly urbanized centers. Let's look at Cagayan de Oro. In 2018, I asked around, what was the percentage of congestion in Cagayan de Oro? For the Cagayan-de-Oro male dorm, for an ideal capacity of 200, they had 2,442 inmates. For the female, for 52, it's 372 inmates. So congestion rate was as high as 1,108%. The alarming thing is here, because of this situation, that there was an average rate of one death of inmate per month since 2016. In 2016, there were 16 detainees who died. In the year 2017, 12 detainees died. And in the first half of 2018, 11 detainees died. Okay, so without plea bargaining, there's high volume of cases resulting in delay in disposition of cases. And yet we had a very low conviction rate in drug cases. I believe this is not just my rate. I think this is national. I don't know. But in other words, many accused simply languished in detention centers at the expense of the government, only to end up being acquitted. When I became a judge in 2010, the law was already 8 years old by that time. When I entered, I had like 400 cases of drug cases which were filed as early as 2002, 2003, and 2004. So these were not yet disposed as of 2010. So the people were just there in the detention centers, government paying for them. And then at the end of when I finally disposed of these cases, many of them were actually acquitted. So you have to look at the economic expense of all of these incarcerations. So the general view or emphasis is that drug use is a criminal offense and drug problem is a problem of criminal law enforcement. So the policy on sustainable program of treatment and rehabilitation, this was the green light that I saw in our declaration of policy, was hardly applied or availed of. Okay, that is why in 2014, in the case of People versus Holgado, the Supreme Court made this pronouncement lamenting the clogging of the courts with prosecutions under RA 9165 involving small-time drug users and involving minuscule amounts of drugs. The Supreme Court said that all these executive and judicial resources expended to attempt to convict an accused for 0.05 gram of shabu under doubtful custodial arrangements will hardly make a dent in the overall picture. It might, in fact, be distracting our law enforcers from their more challenging task, which is to uproot the causes of this drug menace. So there we have now the introduction of plea bargaining in drug cases with the landmark case of Estiponda versus Lobrigo, whereby the Supreme Court ruled that Section 23, which disallows plea bargaining, is actually unconstitutional. Okay, so starting 2017, court says now you can have plea bargaining in drug court. So how do we do this? Next slide, please. The Supreme Court came up with the SC Resolution 180316-SC in April of 2018, which provides the adoption of the plea bargaining framework in drugs cases. What are the main features of this resolution? First, it allowed plea bargaining in Section 5 and Section 11 cases to Section 12 with penalty of as low as 6 months imprisonment. Now, if you have a penalty of 6 months imprisonment, that case, the accused can apply for probation. And then finally, the important feature of this is the introduction of treatment and rehabilitation as part of the penalty for drug offenses. So because of plea bargaining, we all know that, fast disposal of cases, reduction of jail population, we still have to study to what extent. And then, of course, high demand for DDE, the drug dependency examination, because it is now part of the penalty in drug cases. So DOH, Department of Health, had to step up by adding personnel and facilities to accommodate the influx of clients and accredited private physicians to address the growing demand for drug dependency examinations. So with the lowering of penalty, accused were able to avail of the probation law. And in my case, in my experience, I even released them on recognizance pending their application for probation. So in that sense, we help reduce the jail population. Okay, so the Supreme Court, through the Estipona case and the resolution, wittingly or unwittingly made a policy shift from mere criminalization to addressing and recognizing the drug problem as a health issue with underlying socioeconomic factors. So in a sense, there is a policy shift, and even in the, if you compare it to the the way things were before, where drug cases were like involved only the five pillars of the justice system. This time we have more stakeholders coming in. Now we have the Department of Health, we have the LGU, the Probation and Parole Office, the jail. Even the jail officers had to open up a new program called Katatagan Contra Droga sa Komunidad, the SWD, and the community. So you have more people involved in the process because now we recognize the drug issue as also a public health issue. Let's look at the congestion again. So I compared the 2018 figures I had, and I had somebody ask the jails, ano, kumusta na ngayon? Last 22 April, bumaba ng konti, but it is still congested. For Cagayan de Oro, it's 689%. Compared to 1,118%, that's better, no? But it is still very much congested. For female dorm, it's 397% congestion. For Miss Or, it's 223. For El Salvador City, it's 60% congested. So there. The question now in our minds, where is plea bargaining going? Okay. One major obstacle, or maybe the major obstacle in this plea bargaining process is the objection of the public prosecutors due to their own circular, the Department of Justice Circular number 27. Which allows prosecutors to consent to plea bargaining in Section 5 cases with a penalty of life imprisonment only if accused will plead guilty to Section 11, which is penalty of at least 12 years. So, syempre, yung mga accused, why would they plead guilty to Section 11? It involves 12 years in prison, but it doesn't make sense. So anyway, and then the accused would insist, why is it that the Supreme Court guidelines say we can plead guilty to Section 12? Of course, we would like to plead guilty to Section 12. So this is what happens in court. Anyway, I know for a fact that many judges have overruled the prosecution's objection to plea bargaining in Section 5, asserting that ultimately plea bargaining is subject to the discretion of the court, and that we cannot be bound by the circular of DOJ, which does not bind the court. So anyway, let's look at some pronouncements of the Supreme Court through resolutions and jurisprudence. And let's see. Okay, in April of 2019, the Office of the Court of Administrator released to us Circular 80-2019, which cites an unbanked resolution. Unbanked meaning everyone participated. I just quoted this very strong wording. It says, if the objection to the plea bargaining is solely to the effect that it will weaken the drug campaign of the government, then the judges may overrule such objection. Judges must decide cases based on evidence, law, and jurisprudence, and they cannot just defer to the policy of another branch of the government. By the way, I'm just reminded that the range of reasoning of judges in overruling the objection of the prosecution also ranges from saying that, you know, we have the discretion to overrule the objection of the prosecution to as grave as some judges even declared DOJ circular as unconstitutional. So many of these cases are now in different Court of Appeals on certiorari, and some have already reached the Supreme Court. So we are also waiting for resolutions of those certiorari cases. Let us look at one of these ruling of the Supreme Court in Saira versus Senos. What happened here is that the lower court disallowed plea bargaining because of the objection of the prosecutor. So the accused went up to the Supreme Court and said, look, the RTC judge here, acted in excess of jurisdiction, etc., with great abuse of discretion because it did not follow the Supreme Court, resolution or circulars regarding plea bargaining. But the Supreme Court affirmed the RTC decision. The court said the use of the word may signifies that the trial court has discretion whether to allow the accused to make plea of guilty to a lesser offense. But the court said plea bargaining requires the consent of the accused, the offended party, and the prosecutor. This one is very interesting. In September of 2020, magkakasunod lang itong mga kaso na to, no? There's Pasco versus People promulgated by the Second Division. This time, the RTC allowed the accused to plea bargain to Section 12 over the objection of the prosecution, but this allowed him to apply for probation. When the case reached the Supreme Court affirmed the RTC decision, which allowed the accused to plead guilty over the objection of the prosecution. And moreover, the Supreme Court found the accused eligible to apply for probation. So very liberal. Then finally, we have the controversial case I was telling you about at the start of my talk. Okay, so this is the Reafor case. It's now in the minds of the judges now. Promulgated on November 16, 2020, but released only recently. Here, the Supreme Court ruled that the RTC gravely abused its discretion in granting the motion to plea bargain over the objection of the prosecution. The Supreme Court ruled that the respondent's plea of guilty to a lesser offense made without the consent of the prosecution and his subsequent conviction to a lesser offense is void ab initio. The problematic thing here is the Supreme Court also said, since it is a void judgment, therefore it will not acquire immutability. It can be questioned anytime because it is a void judgment. Therefore, this case has to be thrown back to the RTC, go to trial. Our questions now in our minds as RTC judges, what happens to all of those cases where we allowed the accused to plead guilty to Section 12 over the objection of the prosecution and are now under probation or have been released, etc., etc.? Will the prosecutors refile the case back in court? We're talking of hundreds and thousands, or maybe thousands of cases. So there, as I said at the start, this case has not yet attained finality, but it's very dangerous. So finally, what are the effects? Should Reafor ruling be affirmed? Practically, no plea bargaining drug cases will materialize in many cases, or most cases, because prosecutors will object to proposals because it is not allowed under their circular. With no plea bargaining, all cases will proceed to trial. Clogging of court dockets is certain, and jails will be congested all the more, as trial of drug cases will take longer to conduct, especially now with the restrictions brought about by the COVID-19 pandemic. Now we all know how urgent the situation is. But I don't want to end my presentation with this. I want us to look at things to look at possible ways forward. This morning I was listening to Chris Nyrop's discussion, and one takeaway that I like is he says, start with whatever you can start. These are ideas that I'm toying around in my mind, and I think it will be good to discuss this among the judges. Supreme Court maybe can craft and promulgate new rules of procedure governing cases under RA 9165. You know, in family courts, they have their own special rules, especially concerning children in conflict with the law. They have diversion under that Supreme Court rule. And the Supreme Court is mandated under the Constitution to promulgate rules of procedure. So maybe it is time for the Supreme Court to do that for RA 9165. The other thing that I was thinking of is that instead of addressing major controversial issues such as decriminalization or depenalization of drug offenses, which need legislative work, perhaps we can focus on the more urgent issue where we can get consensus on, which is the jail decongestion. Is it possible for us to introduce a court-initiated diversion or maybe new rules on bail for drug offenders? These are questions that I would like to leave with you. So in closing, I repeat, the lens by which we view the drug problem influences the way we address and find solutions to it. So it is important to continue this conversation and share the lens of harm reduction to more people. Earlier, I was asking myself, is there room or space for harm reduction in the Philippine legal system, given that we have RA 9165? My answer to my own question is this. For as long as we appreciate and understand the importance of harm reduction, we will and we should find ways to make room for it. The Supreme Court has shown us by allowing plea bargaining despite the odds. I believe it is time for the Supreme Court to further cement the path towards harm reduction by promulgating new rules of procedure governing drug cases, pursuant to its constitutionally mandated authority to promulgate rules of procedure. I am inspired by this summit's slogan, let us rethink, reshape, and reimagine. Thank you very much.
Thank you, Judge Ason. Thank you for everyone who has questions. We will be taking note of your questions. Please do type your questions at the Q&A box near the chat box. And so Judge Ason has given us the green lights, the single green light in RA 9165, and the red lights starting from the policies, and discuss the case of that allowed plea bargaining in cases of in drug cases. Discuss the effects of plea bargaining in drug cases. Mostly, she said, now there's faster disposal of cases, reduction of jail population, high demand for drug dependency examination, and with the lowering of the penalties because of the plea bargaining, accused were able to avail of the probation law and release on recognizance pending application for probation.